Today we'll talk about the difference between trial and appellate courts, or courts of appeals. This is a representation of a trial court. At the trial court, we have a judge presiding over the trial. Often we have live witnesses sitting in a witness box giving testimony to the jury. And here I have a jury of 12. Sometimes you may have 8. There may be a different number. And this represents the parties. If this is civil court, then you have the plaintiff and the defendant with their counsel. If it's criminal, then you have the prosecution and the defendant with counsel. So this down here is the public. So our trials are open to the public. People can come and sit in this section. That represents the appellate court. 3 appellate justices. We don't have a jury nor witnesses. We do have lawyers, but they aren't often in front of the appellate justices for oral argument. So let's talk about some differences. At trial, this is the court of original jurisdiction, origin, beginning, original jurisdiction. All litigation begins in the trial court. At trial, the judge will preside over determinations of what evidence may be admitted to the jury for consideration. And when they're deciding the case, the jury deciding the factual issues, they may only consider that information presented to them in the form of evidence. The witnesses may be fact witnesses, people who had direct observations related to relevant facts, or expert witnesses, a person qualified with special knowledge that allows them to give testimony to the jury even though they didn't directly observe the facts in the case. So what is the role of the appellate court? If a party loses and there's a final determination of a losing issue, that party may then file a notice of appeal, at which point certain documents, such as the transcript of the trial and other pleadings, are transferred electronically to the appellate court. The appellate justices then review and decide if oral argument is proper. If it is, then the attorneys for each side will appear before a 3-judge panel, likely, and stand here and present oral argument, trying to persuade the justices what? Well, as I said, a losing party upon a final issue can file an appeal, and they are saying something unfair happened here, or the judge made a mistake. The judge committed some kind of error, didn't apply the law correctly. At the appellate hearing, no live witness testimony, no new witnesses, no new evidence. Everything reviewed here already occurred there. So this is just a review of what occurred at trial. And these justices can make several different rulings. They can affirm what happened in the lower court. They can reverse what happened in the lower court. They can modify what happened. They can remand the case back to the lower court for further proceedings. They can sometimes vacate judgments. Those are in civil cases commonly. In a criminal case, they might find there was no error committed at the trial court. Sometimes the justices reach their decision without any oral argument, simply by reviewing the transcript and reading the briefings submitted by the attorneys. This is the difference between trial court, original jurisdiction, and appellate court with appellate jurisdiction. How does federalism relate to the differences between trial and appellate courts? Because of federalism, we have state trial courts and separate federal trial courts. If a lawsuit is in a state trial court, the appeal must be filed or must be heard by the state appellate court. As the name implies, there is a higher court of appeals, often called the Supreme Court of the state. And if the party loses at the Intermediate Court of Appeals, then they may file an appeal to that highest court who has the final determination. Be aware, each state can name their courts as they see fit. In many states, the state trial court is called circuit court or district court. However, in New York, this trial court is called the New York Supreme Court. So be mindful that different states may name their different levels, original jurisdiction, trial court, intermediate court, and highest court by different names. Now, what happens if a party loses in federal court? Federal trial court is called the U.S. District Court. If a party loses there, then they may file an appeal to the Intermediate Court of Appeals. Depending upon which state the federal trial occurred, the party will have to file the appeal to the correct circuit. So, for example, if the trial occurred in Houston, Texas, the federal courthouse in Houston, then the party seeking an appeal would file with the Fifth Circuit Court of Appeals. If the trial occurred in Arkansas, federal court in Arkansas, the party losing would file an appeal with the Eighth Circuit Court of Appeals. In California, the Ninth Circuit Court of Appeals. In New York, the Second Circuit Court of Appeals. What if the party loses at the intermediate level and they want to file an appeal with the highest court of appeals at the federal level? It is unlikely their appeal will be heard. Approximately 7,000 cases are heard in our intermediate courts of appeals and seek to be heard by our U.S. Supreme Court. And each year, they choose to hear between 100 and 150 cases usually. So for most federal litigants, their journey ends at the Intermediate Court of Appeals. And that is the final decision in their case. So in conclusion, be aware these are two separate court systems. One is operated by the U.S. federal government, and one is operated by a state government, entirely separate because of dual sovereignty and federalism.